Yeah, hi, this is Alcam. Welcome back to my channel. I'm in what was Michelle's room. I'll get some information about the Supreme Court and the January 6th um, situation. Yeah, this is from CNN. They're wondering if the certain law that were used for the Enron case back in 2002 applied to the January 6th folks. We have a picnic downstairs, so you have to apologize. I have to apologize, but well, anyway, this is important too. But this is what the CNN said. Take away from the Supreme Court argument over obstruction charge used against rioters in January 6th. Written by John Fizz, Marshall Cohen, Tyrone Sneer, and Hannah Rezovitz of CNN. Sorry, I can't pronounce names. Anyway, this is what they said. Supreme Court's conservative majority indicate Tuesday that they may toss out a charge prosecutor has lodged against hundreds of people who took part in the January 6, 2021 riot on the U.S. Capitol. This is CNN saying riot, not insurrection, a decision that could force the Justice Department to reopen some of those cases. Oops. So during the 90-minute arguments, most justices signaled concern with how the Justice Department is using the law enacted by Congress more than 2 decades ago in response to Enron accounting scandals. Those who don't remember Enron, it used to be a big Angie company that was into a lot of stuff, including broadbanding, which is like streaming is today. And they were caught destroying evidence, shredding the stuff. That's why this law was enacted. Critics claim that the felony charge, which carries a prison sentence up to 20 years, was intended to prevent evidence tampering, not an insurrection. Again, that's not what they said originally. They said riot. In support of a president who lost a re-election. Did he really lost the election? The court decision, expected by July, could have significant ramifications for 350 people who were charged with obstruction and official proceeding for the part of the Capitol attack, including more than 100 people who were already been convicted and received prison sentence. So this doesn't mean that people who vandalize the building or attack police officers are going to be included in this. The High Court ruling could also affect the federal election subversion criminal case pending against former President Donald Trump, who was also charged with the obstruction crime. Here's what is known about Tuesday's oral arguments. Traumatic day boiled down to technical argument. The appeal was brought in by a former Pennsylvania police officer, Joseph Fisher, who was charged with multiple crimes for pushing his way into the Capitol after attending Trump's rally outside the White House on January 6. Fisher's attorneys told the justices that the prosecutors overstepped by charging his client with what critics previously framed as an anti-shredding law. Like I said, shredding documents. I didn't see anybody going into the building with shredders. Most absent from the oral arguments Tuesday was a recognition of the traumatic and deadly turn of events that took place across the street from the Supreme Court 3 years ago after Trump gingered up a crowd with false claims of fraud and encouraged them to march to the Capitol and fight like hell. A lot of Democrats also say fight like hell too. That doesn't mean anything. Instead, the discussion turned largely on technical and logistic debate about the meaning of the words in the law, in particular the word otherwise. The 2002 law made it a felony to corrupt, alter, destroy, or to mutilate a record with the intent of making it unavailable for the use in an official proceeding or otherwise obstruction influence, or impairment such as proceeding. Fisher argued that taken together the law was geared towards prohibiting record destruction, but the Justice Department said it was swept far more broadly than that, encouraging a wide range of actions, including physical intrusion that would obstruct a proceeding. No, because there used to be an accounting firm, Anderson something. They were involved in this nonsense too. That's why that law was enacted. The key word is otherwise. Justice Brett Kavanaugh, often a critical voice in high-profile cases, said that at one point the quiz of Solicitor General Elizabeth Prelogar, it would be odd to have such a broad provision tucked in and connected by the word otherwise. That position seemed to draw attention to Chief Justice John Roberts as well, who at one point sharply pushed down on the government for trying to separate the evidence portion of the law from the provision dealing with obstruction. You just can't tack it on and say, look at it as it was standing alone, Roberts said, because it's not. Occasionally, Prelogar sought to remind the justices of the details of the case in hand, and one especially pointed response to the question from Caviar about the other charges the DOJ had used in the Capitol riots prosecution. They keep saying riots. Prelogar argued that Fisher, in advance of the attack, has expressed an interest to storm the Capitol and use violence as necessary to disrupt the vote. Disrupt the vote is not the same as destroying the paperwork. He said you can't vote if you can't breathe. That's nice. Prelogar argued referring to Fisher's text before January 6th, and then he went to the Capitol on January 6th with the intent of mind and took action, including assaulting a law enforcement officer that did impede the ability of the officer to regain control of the Capitol and let the Congress finish its work. Stealing an election. Conservatives asked about left-wing protests. There was heavy dose of whataboutism from the conservative judge who repeatedly brought up the left-wing protesters while pressing both sides about the exactly which conduct they believe would and wouldn't be covered by the felony obstruction law. Justice Neil Gorsuch proposed several hypotheses, whatever it is, to Polsher, asking if the prosecutors would use the law to charge someone who participated in a sit-in that disrupted the trial at a federal courthouse, or who would caught pulling a fire alarm before the vote in Congress. He didn't mention or Representative Jermaine Bowman by name, but the illustration to the New York Democrat was clear. He pulled the fire alarm shortly before critical vote in a government funding bill in September. Bowman later pleaded guilty to a misdemeanor offense and was censured by the House. Justice Samuel Alito brought up the disruption at the Golden Gate Bridge that occurred Monday. Pro-Palestinian protesters' anger about Israel's war against Hamas in the Gaza Strip blocked rush hour traffic, leading to more than 30 arrests. So what if similarly that happened all around the Capitol, so that all the bridges from Virginia were blocked and members from Virginia who needed to be appearing at hearing couldn't get there or were delayed in getting here, Alito said. Would that be a violation of this provision? Prelogar differentiated those cases by pointing out that January 6th was a far more aggressive and multi-pronged assault with direct aims to shut down a specific proceeding. She said many of the January 6th rioters violated, breached multiple police lines, brought in tactical gear and weapons, and made explicit threats before arriving in D.C. Of course, liberals appeared to unite against rioters and Texan grounds. And there's the three of them. So record three liberals. 1, 2, 3. Appeared to be lined up in favor of the Justice Department position that The federal obstruction law is broad enough to include the rioters' conduct on January 6th. Yeah, right. The law, Justice Ellen Kagan said, would have been written by Congress to limit its prohibition to evidence tampering, but she stressed it doesn't do that. Kagan, Justice Samir Samota, and Cassidy Brown Jackson, press attorney Jeffrey Green's on the plain text of the law, embracing a concerned notion of Texism or reading the law for its plain meaning without considering legislation, history, and other factors. Jackson noted the language in the statute does not use the term evidence, but rather uses the term official proceeding, which is defined including a congressional proceeding. Trump loses in the background. Though Trump is not party to the case, the appeal indirectly thrusts him into the Supreme Court docket for a third time this election year. In March, the justices unanimously ruled that the former president should appear on the ballot, despite the constitutional ban from Colorado. Colorado disputed his claim he violated the 14th Amendment insurrection ban because of his action on January 6th. There was no insurrection. They keep saying riot, even in the CNN article. Special Counsel Jack Smith had charged Trump with the same obstruction crime prosecutors filed against Fisher and more than 350 otherwise involved in the attack. The former president and presumptive GOP nominee will also certainly use a win for Fisher to try to further undermine the Justice Department prosecution of the January 6th defendants, meaning that if the Supreme Court rule in favor of these January 6 folks, it's going to be a bigger headache for the Justice Department, a bigger headache for Jack Smith, a bigger headache for Biden, because if they have to do these cases all over again, they're not going to have time to do it in time before the election. It's going to be a huge boondoggle for Biden. So how much the Fisher case will spill over to Trump's is open for debate. Smith argued that the obstruction charge against Trump is based on a fake slate of electors the former president intended to have submitted to Congress, not the right itself. That wouldn't destroy paperwork. Unless the court rules broadly in a way that undermines the charge entirely, the case against Trump may stick even if Fisher wins his case. Clarence Thomas was back in court. He wasn't there on Monday. So Justice Clarence Thomas was absent from all arguments on Monday, with the court refusing to explain his absence. He was back Tuesday for a case that critics says he shouldn't be involved in at all. Screw you. The Fisher case had promoted some liberal critics of the court to demand that Thomas rescue himself. That's because Thomas' wife, Gina Thomas, attended Trump's rally on January 6th and plotted with Trump's allies on the way to keep him in power to lose the election, which has been debunked. Thomas has ignored the request to rescue and posed a number of questions that challenge both sides in the case. There has been many violent protests that interfere with the proceeding, Thomas asked Prologer, pressing at the time that he returned to repeatedly during the arguments. Has the government applied this provision to other protests in the past? Prologer said that the Justice Department had applied the law more broadly than its an evidence tampering case, but acknowledged it was not used previously against a situation where people had violently stormed a building. But that, she says, was based on the unusual nature of the Capitol attack itself. In other words, she says, that circumstances ever happening prior to January 6th. But we had other situations that happened at the Capitol, other protests by Democrats, and they had not been charged with this obstruction law. So this call about having Thomas being removed from the case, it's not going to make a difference because you still have enough conservatives to rule against the Justice Department. Remember, for I think it's nine people on the court, and you had 3 Democrats, you had 6. Even if you Thomas had rescued himself. There's still 5 conservatives on there. I doubt that they're going to rule in favor of the DOJ on this one. I really doubt it. We're not going to get a 9-0 decision, but it looks like the January 6ers are going to win this one. So I don't know what to tell you. Sometimes you try to apply things that don't apply, and things don't always stick as well as you hope they do. So it's like you're trying to put a shelf with 20 pounds of stuff on it and use a tape that can only hold 5 pounds. You know what happens? This is going to happen. Okay, this is Alcan saying so long for now. Don't forget to stop. And by the way, the jury selection in the Trump case, they got 6 jurors today. Yesterday they couldn't get none. They had 50 people says, no thanks, we're not interested. So I don't know if they need 6 more and some alternate. This is not like in the Bronx. This is a different situation. All right, take care, everyone.